Today we're going to be talking about GDPR. The General Data Protection Regulations apply to anybody who keeps any information about anybody else. And as therapists, you will be keeping information about your clients. And it's really important that you do this because that's the only way that you can treat them safely. GDPR also applies to data which has been pseudo-anonymized, and that can involve case studies. So normally, because we give our case studies a reference number rather than a name, they should be completely anonymous, but sometimes people include things in their case studies which allow them to be identified. So for the case studies, at the front sheet, the consultation forms, you've got your clients to sign the GDPR policy. So let's look at the principles. Data must be processed lawfully, fairly, and in a transparent manner. And process can just mean that you have written it down and you put the information in a folder and you look at it each time you treat the client. Data must be collected for specified, explicit and legitimate purposes. So you can't just collect anything from people. You have to have a good reason for what you collect. You can't carry out further processing in a manner which is incompatible with why you've collected the data. Only collect what data you need and keep it accurate, and sometimes you have to keep it up to date as well, but I will cover that a little bit later. Only keep the data for as long as necessary and make sure that your data is processed and stored securely. So you've got to have a lawful reason to process your data. And if you're a therapist, you have the lawful right to retain client data in order to offer the best possible treatment for the client and give them advice, and to ensure that your insurance is valid, which is a really important thing for you. You also need to make sure that you're processing data in a transparent manner, and that means you have to give the client a copy of your GDPR policy if they want it, and that should say exactly what is going to happen with their data. And that will be different when you start charging clients to the one you're using at the moment. At the moment, the GDPR policy, which you've got at the front of your consultation forms, is my GDPR policy. And because I have to let my assessors see your case studies, VTCT can have a look at them. It's all anonymised, but there is still that risk of disclosure. You have to let the client know exactly what's happening. So I will send you a template which you can use to produce your own GDPR policy. What's really important is it's less important what's in it. What's more important is that you do what you say. It can also be useful to have a copy of the policy on your website, and then you can refer to people, and the policy must say exactly what will happen to their data, including who will see it and how long you'll keep it. I always offer clients a copy of my GDPR policy, and I've actually never had anybody accept the copy. So I don't think it's something most people are interested in, but I do have a copy of on my website, so it is available to them if they want to see it at a later date. And I always offer them, and I always write down that I have offered them a copy. Collection of data. Data must be collected for specified, explicit and legitimate purposes. So as a therapist, you are legally allowed to collect information about your clients. Further processing. So anything else you do with that data can't be incompatible with why you've collected it. So if you wanted to sell all your clients' email addresses and details of their presenting conditions to a third party, you would not be able to do that without getting their permission, and they wouldn't give you their permission. So this is to stop people doing that. So it's stopping you providing your information and then the person you hand it over to uses it in a way you're not expecting. Only collect what's needed. So this can be a little bit fuzzy for therapists as we talk to clients about lots and lots of areas. But the test has got to be, does what you are collecting affect your treatment? And if it does, you're fine. And if it doesn't, then you shouldn't be collecting it. Now, collecting it basically means writing it down. So just because a client tells you something doesn't mean you have to write it down. An example of this is collecting GP data or information. Historically, we all collected GP information, and I know some therapists still do, but when GDPR came into being, I reassessed what I was doing and I looked at my forms and I thought, I have never ever contacted a client's GP, and actually I never would. I might send the client to their GP, but I will never contact the GP directly. So actually I've got that information and I'm not using it, so actually I shouldn't be collecting it. So just have a look at what you're collecting. Keep data accurate, and so that might mean that you have to update the data. Ideally, go back if there's something important and date the update so you know when you were made aware of this. So this is for only active clients, so you don't need to go and chase down your clients who are on a break from you, and you don't have to keep their information up to date at all. It's only for active clients. So you do that at the beginning of their next treatment. So, hi, how are you doing? Anything changed from last time? Anything I need to know? Only keep the data for as long as necessary. So data must be kept for at least 7 years after the client's treatment. And this is an insurance requirement. And if the client doesn't want this to happen, you cannot treat them because you will not be insured. If you're treating a minor, you need to keep their data for 7 years from their 18th birthday. So that is a significant amount of time. Data must be processed and stored securely, so paper copies of information should be kept securely, ideally in a locked cabinet, but as long as they're not available for other people to see, then as long as your GDPR policy reflects what you actually do, then that's good. Computer held copies should be held securely, and you need to make sure you've got things like firewalls and password protection in place so that makes it more difficult for you to be hacked. And any data stored on the cloud should also be stored securely. So the processing and storing includes disposal of the data. So paper copies, ideally these should be shredded. Data must be securely deleted from a computer, and it's not good enough just to press delete, because deleted files can be recovered. So you need to make sure it is completely gone. And especially when you're disposing of old computer equipment, ideally you need to format your hard disks to ensure that all the data is moved. And any data on the cloud should be securely deleted. And it can be difficult because you might have data in different places, but it's really important that you go and you get rid of all that data. So, questions. As a self-employed therapist, do I need to register as a data controller? So companies where they are doing lots with the data, where they're passing it on to different people, they have to have a data controller. But as a self-employed therapist, you're keeping the data yourself, you're using it for your treatments or to inform your treatments, but you're not passing it on to anyone else. You do not need to be a data controller. Right, my client does not want to provide me with any information. Can I still treat them? So, as a minimum, your client must provide contact information and enough medical information so that you can check they're not contraindicated. And you must record the date of all treatments and what treatments were carried out. If they won't do this, even for a taster treatment, you cannot treat them because you will not be insured. And some clients will say, well, I don't mind, I'm willing to take the risk. it's not their risk. If this something happens here and you're found to have done this, you're not going to be treating, because you're not going to be able to get insurance. So you've got to have the minimum information. And if you haven't checked they're not contraindicated, it's really not safe for you to treat. Can I use my client's details for marketing? Right, okay, this is a little bit fuzzy here. People talk about the term soft opt-in, and if basically the client's been to see you and they didn't opt out of receiving any messages from you, they'll probably be happy for you to send them information about your products. But I would say I would always make sure that you actually get specific permission for them to go on your database for promotional emails. And I actually use MailChimp, which is great because it makes sure that I comply. So it makes sure I've got all the information I need in my emails, and it means it gives me an opt-out. So people can opt out at any time, and I don't need to be involved in that. When I first started, I tried to do it manually, and people would say, can they come off my data list? And then I'd do a backup and restore, and they'd get back on, and I never got into any trouble, but I could have done. So something like MailChimp to send out, monthly or quarterly emails saying what you're doing with your business, any new products, any special offers, I think is a really good idea. Does GDPR apply to information I have on my phone? Yes. And you may notice that if you call me, I don't always know straight away who you are, because I don't keep information on your phone, and I delete your texts and messages when we've spoken. So that's the way I deal with it. Right. If a client contacts me to book a treatment, do I need them to sign my GDPR policy before they give me any information about themselves? And normally that's a no, because you're not documenting any information about them. So what you're probably going to be doing is taking contact details, just in case you need to get in contact with them before their treatment. But what I always do is I check that they're not contraindicated, because I don't want them to come all the way to me, get in my treatment room, we do the proper consultation, and then I go, oh, sorry, you can't have a treatment. They feel annoyed because they've had a wasted morning. I feel annoyed because I've lost a client for that treatment, and maybe I've lost a client permanently because I've upset them. So on the phone, I will always check that they're not contraindicated. I'll go through the main contraindications for the therapy they want, but I'm not going to write this down. All I'm going to write in my diary is their name and contact details, and I will do my full consultation when I see them. Now, I might need to, with COVID-19, I might need to do that by phone, but that would be a separate appointment where I would send them my policy, I would send them my consultation form, and then I would call them and we would do that. But GDPR would be then sorted, because they would have seen my policy. But so generally it's no, but you do have to get them to do it before you complete the first consultation. Okay, I work in a multi-therapist clinic. Can client files be shared between therapists? So it can be really useful. So I've worked in a clinic where I treated the same person as the physio did, or the massage therapist did. I was offering just reflexology when I was there. And it can be really useful to see what the client's doing with the other therapists. But you have to have something specific in your GDPR policy to allow you to do that. So that's the end of the presentation. So thank you for watching. And if you do have any questions at all about GDPR, please do get in touch. I will be sending you a copy of a policy that you can use as a template to create your own GDPR policy for when you are starting to work. But it is really important that you don't just take the template, that you actually look at it and think, how am I going to keep people's data safe? So thank you.